Yes.
Just to recapitulate, my lord.
No need.
No need.
You're just only one day away, Mr. Chief.
I don't know, not. I'm not going to take. I only want to make one point.
Only one submission in this, my lord. I filed an implementing application for the auto rickshaw unions.
For the
auto rickshaw drivers union.
Who want to oppose?
This is this side now.
Yes, sir.
Fortunately, yesterday was more on my side. Now the that side, my lord, is getting populated a little more.
Yes.
Yesterday, my lord, I almost stopped at the point where I said that if the statute is clear and the law has been declared by this court, there can't be a policy contrary to that. And then, Lord, I said that insofar as a rider is, or an owner is concerned, he's entitled to register it as a transport vehicle and get a contract carriage permit, both of which can't be denied unless there is a good enough reason which should be contained in the rules, which are made, my lord, by them. Now, if I satisfy all the requirements that are there in the rules for being granted a contract carriage permit, I should be granted it, unless there's some rule which says I should not be granted it. Now, the case of the state can't be that dehors the rules or dehors the act. I will now make a policy, and that policy will say I will not give permission to anybody to use it as a contract carriage. There, my lord, is where we stop. I want to start, my lord, my submission today, pointing out that the right to utilize my vehicle as a taxi or a transport vehicle is a fundamental right. And therefore, I have a fundamental right under Article 19(1)(g), which is recognized in 2 judgments. I'll place those judgments first before your lordships. Lord Sagir Ahmed and Mithilesh Garg. I'll just pass it on. Lord has the first one, Lord, is a Constitution bench judgment on under the old Act when they were license Raj, and even then, whether to operate a vehicle as a transport vehicle was a fundamental right was a question. In Sagir Ahmed,
Give it. Yes.
para 12 on the 4th page. Let me come to the extract, a few lines before the extract at para 12. Under the Indian Constitution, it starts.
Yes.
My lord's got Sagir Ahmed. I think my Lord Justice Joshi has Sagir Ahmed. Para 12. 5 lines before the extract.
Yes.
Under the Indian Constitution, the contract carriers as well as the common carriers would occupy the same position so far as the guaranteed right under Article 19(1)(g) is concerned. Both are liable to be controlled by appropriate regulations under Clause 6 of that article. The law on the point as it stands at present has been thus summed by the learned judge. The true position then is that all public streets and roads west in the state, but the state holds them as trustees on behalf of the public. The members of the public are entitled as beneficiaries to use them as a matter of right, and this right is limited only by the similar rights possessed by every other citizen to use the pathways. The state as trustees on behalf of the public is entitled to impose all such limitations on the character and extent of the user as may be requisite for protecting the rights of the public generally. But subject to such limitations, the right of a citizen to carry on business and transport vehicles on public pathways cannot be denied to him on the ground that the state owns the highways. Well, that argument is not advanced here as yet, because the roads are the state roads. That's the only argument which is not advanced, I must say.
Yes.
Para 13, we are in entire agreement with the statement of law made in these passages. Within the limits imposed by state regulations, any member of the public can ply motor vehicles on a public road to the extent he can carry on the business of transporting passengers with aero vehicles. It is to this carrying on of the trade of business that the guarantee in Article 19(1)(g) is attracted, and a citizen can legitimately complain if any legislation takes away or curtails that right any more than that is permissible under Clause 6 of that article. Now, all reasonable restrictions are contained in the acts and the rules. And the act and the rules prescribe the entirety of what could be done. We have not challenged any of those, nor are we complaining against any of those. Our entire complaint is you are doing something outside it. If the law therefore permits it and therefore enables me, my lord, to exercise freedom of profession or freedom of business, then it is incumbent on the state to take every step to protect that right. The state cannot turn around and do something which will disable that right, which is exactly what's happening today. And that can't be done. Similar, my lord, after the 1988 Act, in the context of motor vehicles, in Mithilesh Garg, I think the other judgment which has been given to your lordship, para 5, my lord. Para 5, Parliament in its wisdom, I'm sorry, my lord, Parliament in its wisdom has completely effaced the above features. The scheme envisaged under 4757 of the old Act has been completely done away with the Act. The right of existing operators to file objections and the provision to impose limit on the number of permits have been taken away. There is no similar provision to that of section 47 and 57 under the Act. Statement of objects and reasons of the Act shows that the purpose of bringing in the Act was to liberalize the grant of permits. Section 71(1) of the Act provides that while considering an application for a stage carriage permit, Regional Transport Authority shall have regard to the objects of the Act. Section 82, which is the harbinger of liberalization, provides that the RTA shall not ordinarily refuse to grant an application for permit of any kind made at any time under the Act, which was the submission I made yesterday. There is no provision under the Act like that of 47(3) of the old Act, and as such, no limit for the grant of permits can be fixed under the Act. There is, however, a provision under 71(3)(a) of the Act, under which a limit can be fixed for the grant of permit in respect to the routes which are within a town having a population of more than 5 lakhs. Then, Lords, may kindly see on 176 near Placetum B.
Yes.
Overcrowded buses, passengers standing in the aisle, persons clinging to bus doors, even sitting on the rooftop are some of the common sights in this country. More often, one finds a bus which has a noisy engine, old upholstery, uncomfortable seats, continuous emission of black smoke from the exhaust pipe. It is therefore necessary that there should be plenty of operators on every route to provide ample choice to the commuter public to board the vehicle of their choice and patronize the operator who is providing the best service. Even otherwise, the liberal policy is likely to help in the elimination of corruption and favoritism in the process of granting permits. Restricted licensing under the old Act led to the concentration of business in the hands of few persons, thereby giving rise to a kind of monopoly, adversely affecting the public interest. The apprehensions of the petitioners that too many operators on a route are likely to affect adversely the interests of weaker section of the profession is without any basis. Transport business is bound to be ironed out ultimately by the rationale of demand and supply. Cost of a vehicle being as it is, the business requires huge investment. Intending operators are likely to be conscious of the economics underlying the profession. Only such number of vehicles would finally remain in operation on a particular route as are economically viable. In any case, the transport system in a state is meant for the benefit and convenience of the public. The policy to grant permits liberally under the Act is directed towards the said goal. And then, Lord, para 9. Article 19(1)(g) of the Constitution of India guarantees to all citizens the right to practice any profession or to carry on any occupation, trade, or business, subject to reasonable restrictions imposed by the state under Article 19(6). A constitutional bench in Sagir Ahmed, which I read to your lordship, held that the fundamental right under 19(1)(g) entitles any member to the public to carry on the business of transporting passengers with aid of vehicles. I won't read that extract. After that, it is thus a guaranteed right to every citizen, whether rich or poor, to take up and carry on, if he so wishes, the motor transport business. It is only the state which can impose reasonable restrictions within the ambit of 19(6). Section 47(3) and 57 of the Act were some of the restrictions which were imposed by the state on the enjoyment of the right under 19(1)(g), so far as the motor transport business was concerned. The said restrictions have been taken away. Provisions of 47(3) and 57 have been repealed from the statute book. The Act provides liberal policy for the grant of permits to those who intend to enter the motor transport business. Provisions of the Act are in conformity with Article 19(1)(g) of the Constitution of India. Petitioners are asking this court to do what the Parliament has undone. When the state has chosen not to impose any restriction under 96 of the Constitution of India in respect to motor transport business and has left the citizens to enjoy their right under Article 19(1)(g), there can be no cause for complaint by the petitioners. Here, my lord, a set of people wanted to stop stage permits from being granted liberally, which is basically concentration of those permits in the hands of some. Supreme Court says, we've opened it up. The state has opened it up in exercise of, or to guarantee that right which every citizen has under Article 19(1)(g), and therefore stage permits can now be given liberally. Today, we have a scenario where the state is coming to your lordships and saying that contract carriage permits for motorcycles, which is otherwise allowed under the Act and guaranteed not by an order of this honorable court, will be done away with because we have a policy of not allowing it. Isn't that, in my humble submission, a complete violation of Article 19(1)(g)? And ultimately, my lord, please see the consequence of it. The consequence of it is exactly what the Supreme Court is saying. The consequence of it is to protect the interests of existing players. Autos, we are not saying take away autos. Autos can remain, you can do everything further to improve their business as well. But today you're saying we will not allow someone else to come, though the law permits it. Can that, my lord, in my humble submission, be said to be a restriction which you can impose outside the law itself, simply by virtue of a statement of objections filed in a writ petition? And that becomes a policy of the state. Then, my lord, the second point which I was making yesterday was on the point, my lord, as to whether, by virtue of either executive instructions or a policy, unstated as it is in this case, could there be a restriction or limitation placed by policy? If there is a policy, it is an unstated, illusory, imaginary policy, not written anywhere else except the statement of objections and a contention taken. There is no government order, no following of transactional business rules in order to formulate a policy, because your lordships know, to formulate a policy as well, there has to be application of mind, there has to be an analysis of all facts, and then a policy of the government. Even if all of that had been done and there was a policy placed before the court, the policy could not be contrary to statute. In this case, that policy is illusory. The policy does not exist. Please see, my lord, in this context, a few judgments very quickly. I'll show your lordships. The first one is, just keep on it. Yes.
They cannot be, in exercise of an executive power.
Yes.
They can come out with any policy, restricting it, though the field is occupied under the Motor Vehicles Act. How would you answer that? Ultimately, in exercise of this.
Yes, Lord. When an issue is covered by statute, executive instructions cannot supplant it, but they can supplement it. When we say supplement it, supplement, my lord, is to enable it further, not to disable it. Therefore, at least my understanding of the law, my lord, is, and I'll show one or two judgments to your lordships, is that in case your lordships come to a conclusion that the entirety of the law has actually been covered by the Motor Vehicles Act, both with respect to permits and with respect to registration as a transport vehicle, because those are only two things. A transport vehicle with a contract carriage permit is a taxi, because there is no separate definition of a taxi. The second I have a contract carriage permit, I can use it for hire or reward. I have to get it registered as a transport vehicle. I have to obtain a permit from the Regional Transport Authority as a contract carriage, because it is from one point to the other, and I charge a customer from point to point. Then I'm entitled to use it as a taxi for hire or reward.
But tell us, Mr. Chinnappa, a situation has come where they have actually, though the statute, the provisions of the Motor Vehicles Act, what you have been arguing, but a situation has come where the government has to step in and to state that this type of vehicles I will stop. How would you answer that?
Yes.
That kind of a situation. Otherwise, given the situation it is such a situation where not even one vehicle can be added to the, to the traffic. So such a situation has come. The government said, now I have to come step in. Though the provisions of the statutes are in a particular way, which I can't restrict, but in exercise of my executive powers, now I will do it.
That they can't. That they can't.
Okay.
It can only be by an amendment to the statute. If I may put it more pithily, the executive power of the state ends when the statute begins. The second the statute begins, then, my lord, there is no power that can be exercised by the state in exercise of 162 power or any other power that the center has to supplant a law or to practically provide an exception to the law. You can only supplement it. And that's the entirety of the power, because the legislature has decided that this is the entire scope of the legislation. And in this scope of legislation, this is what, as a delegate, the state can do. Because, my lord, now the state's power has been restricted to as a delegate. And it has been told that these are the areas where you can make rules, whether it's a central government or the state government. Now, tomorrow's situation, as your lordships point out, has come, where the vehicle population in the city has become so much that there's no space to have more vehicles. Then, my lord, you must legislate to find a way out of that scenario. Like possibly, my lord, in Singapore, they say you buy a car, you have to ensure one car goes off the road. It could happen in one day, my lord, it may come when that has to be done because of the number of cars. But it is essentially a legislative power, because it practically results in some ways of expropriation of a property, which is also a car, and say, you cannot have a car on the road anymore. But also it happens, when your lordships now know that a certain age is fixed for a car. If they say tomorrow, beyond that age, we will not allow a car to ply, or 15 years or 20 years. No cars will be there. So all the old cars will get removed and new cars will come onto the road. That is one way of fixing it. But their policy today is not that because there are too many vehicles, we want to avoid bike taxis. That is not the stated policy. They said we don't want bike taxis for reasons which we don't know, because there is no decision of the government before your lordships, except a statement made in court. That is not policy.
Okay.
Now, please see this judgment in my humble submission at 2006-9 SEC 1, para 62. This, as a matter of fact, possibly is the judgment which fits almost best to this case. Para 62 at page 32. This is, of course, higher standards, NCT. From the above decisions in our judgment, the law appears to be very well settled. So far as coordination and determination of standards and institutions for higher educational research, scientific and technical institutions are concerned, subject is exclusively covered by entry 66 list 1 schedule 7. State has no power to encroach upon the legislative power of parliament. It is only when the subject is covered by entry 25 of list 3 to the constitution that there is a concurrent power of parliament as well as the state legislatures. The appropriate acts can be made by the state legislature, subject to limitations and restrictions under the constitution. I'm sorry. Oh, I'm so sorry.
Nothing between us.
Oh, I see. I thought I was reading, my lord.
No, it's all right.
That.
No. The moment you say Sandhya Nesha, I went to the appearance, that's all.
Oh, I see. And you'll see.
This is in context of NCT. regulation.
NCT.
That's right. Yeah, go ahead.
Now, please see para 63, my lord. On this occupied argument. In the instant case, admittedly, Parliament has enacted the 93 Act, which is in force. The preamble of the Act